Yes, Mr. Ford.
Good morning.
Our notes kept up, you had finished your 6 sub-points under point 8.
Yes.
And we are left only with 9 and 10.
Yes, which I'll deal with briefly. Ninth, we say the position under UK law chimes with EU law in that the employment relationship...
Sorry, I just didn't hear what word you said. The position under UK law...
Chimes.
Chimes.
With EU law in that the employment relationship is with the agency. So UK law also draws the boundary between dependent workers. It requires a contract with the other party. We've not reached the stage of status. Nothing in Uber suggests the contrary. There was no argument in Uber that you didn't need a contract of some sort. And I had a look overnight for what it's worth, my lord, at Gillam. And in Gillam, the Supreme Court affirmed that you do need a contract that said we're going to use Section 3 of the Human Rights Act because it was about whistleblowing in order to grant judges protection.
Oh, of course, I'd forgotten that that was convention rather than EU law.
Yeah.
Yes, thank you.
So you still need a contract. And nothing in Uber suggests the line of authorities in James in a triangular relationship are wrong. So nothing says you can...
Uber was a quite different set of issues. You can look at it still for very general propositions about purpose of interpretation and about the nature of employment relations, but the factual situation, the legal issues are wholly different.
Yeah. No issue about no contract. I mean, if you remember, it was lightly touched on in the Court of Appeal, I think in one of the judgments, but it wasn't, they referred to Ms. Rose not really pressing the point, but in the Supreme Court it wasn't even an issue. So James does remain good law, that under UK law, so far as we understand it, you need a contract. And you only get one with the user if you can imply one. And almost invariably since James, the courts have said, well, you can't imply one unless it's necessary, and it's not necessary because you have a contract that explains why you're working there. So 10th, we say the employment judge correctly directed himself in accordance with Allenby. Question of fact for him to decide, focusing on the Allenby, whether Mr Lutz was a worker or an independent contractor in his relationship with MCG. You'll know the authorities on appeal courts in employment status cases, but it's restated in Uber at paragraph 118 for your note. That's page 922. We say the judge was undoubtedly correct because once it was accepted, Mr Lutz wasn't operating a genuine independent business. It ineluctably follows, applying Allenby, that his relationship with the agency was that of worker. But of course, we don't need to go that far. We just need to show that no reasonable tribunal could have reached that conclusion. So can I quickly go to some of the facts? Because they're both relevant to the application of Allenby, and they're also relevant to the question of whether this court or the EAT could interfere with the judge's decision. And can I begin with, and they're also relevant to how Mr Brown characterises the relationship as we were a payroll and administrative company. So can I begin with the contract between Ryanair and Storm Global? And that is in the supplementary bundle at page 45A. And for your note, the tribunal refers to this at paragraph 27, so that's where he refers to it. And I think we only looked at this very briefly.
Just out of curiosity, I mean, I see why we've been given the 45A, because 45 is rather illegible. What are the bits in red?
I think those were typed because it was impossible to read them on the copy.
Oh, I see. Sorry, that's very. No, of course that made sense.
So we Eversheds kindly supplied a typed copy, and you can see under the services, the supplier undertakes to procure the services under A. It agrees to engage the service companies and make the representatives available to operate as pilots. Under, going over the page 46 at 1, the supplier agrees to provide the services specified to Ryanair. 2, agrees to arrange for the service of the companies, 3, sorry, to be provided. You've already seen 4. 5 is a similar in similar light, and then 7, the Ryanair agrees to pay them fees in consideration of the services. You'll notice under 13, the supplier, that is McGinley, undertakes to specify the training required to the pilots. Under 15, over the page.
We just look at 14.
Yes, there's an indemnity from Ryanair there.
Just not sure. I mean, just again, don't deal with it now. But what's worrying me still is what worried me yesterday, which is how you make this work when the on-the-ground obligations under the working time regulation or the civil aviation working time regulation are plainly on can only in practice be performed by the end user.
Yes.
Now you could say, well, there's a scheme under which the contractual scheme effectively is that the agency promises that the end user effectively, if the end user does not comply with the working time regulations as regards the workers who are supplied, that will put the agency in breach because it is required to see that those obligations are complied with, and Ryanair, the end user, will have to indemnify them. That would make sense of it. Commercially, it'd still be clumsy, but that's what happens in triangular relationships.
I will come to that.
Will you? But the reason why I'm pausing on indemnities is you might expect to find an indemnity from Ryanair saying that if we fail to comply with any of our regulatory obligations, which puts you in breach,
yes,
or to any of the working time which puts you in breach, we'll see you harmless.
Yes.
I don't think it does say that. I had a quick look at it earlier.
Well, it is an indemnity.
It's a more narrow indemnity, isn't it?
Yes.
It's sort of death or personal injury or loss or loss or damage to or destruction of property.
Yes, I don't think I can put it that way. I mean, my lord, I am going to come to this.
Okay, fine. No, I don't want to take you out of your course, but I was explaining to you why those indemnities might be relevant to that analysis.
Yes.
Yep, okay.
Under 15, you'll see then there's an indemnity from the supplier to Ryanair relating to various matters that happen arising from the provision of the services. That's about 8 lines down, pretty remarkable for a payroll company.
It's a much broader indemnity than the indemnity which Ryanair gives to
16. They have to confirm, so the supplier again has to confirm the tax position to Ryanair. 17, McGinley has to ensure company representatives have appropriate tax compliance documentation. 19, in the event of termination and one of the pilot's assignment is ended, then the supplier has to replace them. Going over the page 25, and bear in mind this is now clause 25, this is now Mr Brown saying, well, hinting, but not quite daring to say it, Ryanair's the pilot, the employer. It is not intended the company representative shall at any point be employed by Ryanair. 26, they're contracted through the supplier to provide services to Ryanair. And again, agreed they won't be deemed employees of Ryanair. And 27 is important because it's an express denial that MCG is an agent of Ryanair. So there's no possibility here of finding that MCG had express or implied authority to contract with the pilots acting as agent for Ryanair. And finally, 30, you'll see the supplier even has to appoint a standards captain to act as a technical administrative contact. So we say, when you view that as a whole, completely inconsistent with the way that Mr Brown has sought to characterise it. And then we come to the contract with Mr Lutz. Now, there were some findings about the background to this. In the interest of time, can I just give you the relevant paragraph references, all involving MCG? Paragraphs 32 to 3.
Well, these are findings of the Employment Tribunal.
Yes, 39, 35, 39 to 40.
Hang on, 32 to 33, 35, 39, yeah.
39 to 42. 43, 50 and 66.
Personally, I'd rather read the document and see what the employment judge said.
Well, I'm going to show you the actual document.
Right.
Don't worry, I'm not going to... and finally, 68 to 72. These are about the background to the document.
Oh, I see.
So now we'll come to the document. And remember as well that it's not right to say this document isn't relevant because the employment judge said this contract governed his service with as a pilot. That's paragraph 13 of the ET's judgment. So the contract is at 53. And I think that the court noted yesterday that it's made with Mr Lutz as a party. In fact, he initialed every page. You can see that at the bottom there.
So, oh, I see. Sorry, you're quite right. I'd forgotten he was also a party.
Yes, he is a party.
Yes.
So we don't face a problem of a corporate veil with the service company. He is a party. And we know anyway, the service company, we can effectively cross that out because of the finding on fiction. So if I can just pick it up, I'm showing you this to show the obligations both on him and on the company. C, again, you'll notice clause 1C over the page at 54. Again, we have a denial that the contractor MCG is an agent of Ryanair's. Do you have that, my lord?
Yeah.
And no authority to act for, represent or bind the hirer. So attempting to shut off any argument there's a contract made through the agency. 1D, acknowledged that the service company, well, if you put a line through service company, is engaged as an independent consultant by the contractor to provide the services of the company representative. Now we say, in what sense? That's saying he is engaged by them. In what sense then is he not working for them? They then owe an obligation to use reasonable endeavours to locate or offer the work, which is your note defined in Schedule 1 under E. That includes, of course, the minimum hours guarantee we've already looked at. Under G, they receive an audit of tax compliance, consistent with what the contract with Ryanair said. And under H, if he does...
Are you suggesting really we have to view 1D as rewritten? So
Yes.
that it's understood as something like, it's acknowledged that not the service company, but Mr Lutz is engaged as not an independent contractor, not a consultant, but worker. So that rather than just crossing a line through the whole thing, because it's a sham, we have to reconstruct it in that way.
Well, the actual sham is B. Sham is the substitution clause. That's in the dustbin.
What is that? No, there's two separate shams. There's a substitution clause sham, but there's the interposition of the service company is said to be a fiction.
Yes, sorry if I've misunderstood that. The substitution clause goes, so we know he owes an obligation to provide personal service. So yes, I agree entirely with my lord. That's effectively how you should read D.
Well, I wasn't suggesting it. I was asking what was your case.
Well, that's my case.
Because it seems quite ambitious to me.
Well, no, we say once you strip out the service company as a fiction, that's the effect of it.
Okay.
Hang on 1 second. So you're saying, despite my lord describing it as ambitious, that the effect of D is that it imposes an obligation on Mr Lutz personally to provide services, to MCG.
Yes. To provide his services. It doesn't actually say who to, we just say it's to provide his services.
Well, it's an obligation to MCG to provide services, yes. Well, then we get into words about whether the service that he supplies to MCG is to provide services to the hirer.
Yes.
Very well.
And then under G, they provide the contractor with an annual... the service company, stroke him, provides the annual audit certificate. If he doesn't do that under H, they can terminate immediately.
Did he ever do that? Provide certificates of audit about what Dishford had done? It's rather unlikely.
To be honest, I don't know. I mean, if you remember, he didn't know anything about Dishford. He didn't even. Yes. He wasn't even on the company register as a director, even though they told him he was.
Yes.
So he was left completely in the dark about Dishford.
So it seems most unlikely that he ever did that. Yes. Quite unlikely that anybody ever expected him to.
Well, I don't know what is the honest answer.
If it worked at all, surely the way it worked, I mean, effectively, as you say, he has nothing to do with Dishford. He doesn't know it is. It's set up by friendly accountants for MCG. And if it was complied with, it will have been complied with by them as part of the service, effectively, they provide to MCG.
I don't know. Yeah. And then we get another obligation of service under J. Once again, written through the vehicle of the service company, that he has to be available to perform the work, and now using the terminology on behalf of the contractor for the hirer. And then L, which is important, because if one's looking for what's the source of his annual leave, it's L. Because under L, he has to be available to perform the work between March and October, and 3 of the remaining 4 months of his contract as specified by the contractor. So effectively, he's allowed 1 month off. And if you're looking for where's the contractual source that would be mapped onto the release from his obligation to work, that's it. But I hardly need to state that that is unpaid, of course. Under M, the terms may be varied in writing, and in fact they were, as we'll see, on one occasion. N, he has to operate in accordance with the Hirer's Operations Manual. O, we have denial of employee status. He gives a personal guarantee under F. And then under 2A, I apologise, I'm going quickly with this.
Sorry, where have you got ahead to?
I'm now on page 56.
Yeah.
Oh, sorry, Mr. Brittenden's pointed out to me Q.
Q under 1.
Yes, Q, under 1, the contractor, that is MCG, has to procure that Ryanair has insurance.
Yeah.
1A and 1B is where he gets paid in consideration of provision of the services.
Sorry, 2A and 2B.
2A and 2B, yes. Various other confidentiality obligations and so on.
Fees is slightly odd title, yes, okay. Yep.
And then we have the rights of termination under 5, which is, here it is expressly applicable to both the company and him individually, should the service company or the company representative. And then there's various risks, including engage in serious misconduct, which is, I think, the clause they actually activated when it came to his termination.
Yeah, well, these are all dismissals, termination.
Yes.
For cause.
And then over Schedule 1.
P.
On page.
It's the only one which isn't for cause.
Yes.
Because it depends on Ryanair, who might be acting without cause.
Yes.
Yeah.
And then over the page 60, the work.
Well, right, despite all this talk about 5 years, it's in fact terminable. Have I got that right?
Yes, on 3 months' notice. Yeah. But terms repeated under page 60. You can see under the heading term, this is a contract for a period of 5 years. Under the heading dated 1st of February.
So you accept, as Mr. Brown did, that the legal analysis is that it expires without notice at the end of 5 years, but can be terminated within those 5 years at any time by giving a few months' notice.
Yeah. Just want to check with Mr. Britton if that's all right. Yeah.
Must be right, mustn't it? Yeah, okay.
And then you can see again under work, once more we say this is a personal obligation on him. The company representative shall perform the duties of pilot as required. And the guarantee of minimum hours is at the bottom under 3. So
So where's, I'm sure you're right, don't see the word shall.
Under the where it says work, about 2 inches from the top, in bold there's a little subheading work.
On page 60?
Yes. If you go from the top, it goes dated 1st February term, position of company representative.
Oh, work. Sorry, I was looking at the bottom. Yes, absolutely. Yep, thank you.
Company representative shall.
Yes, thank you.
So that's the personal obligation as well.
As required by the hirer.
As required by the hirer. And then the minimum hours commitment at 3 at the bottom, under which the contractor, MCG, guarantee a minimum hours once he's been there for a year.
The definition of services, I've just gone back to the first page of the contract, is carrying out the duties of a pilot of a 737-800 aircraft.
Yes.
So the services are actually defined.
Yes. So unless there's anything else, my lords and my lady, that was what I was going to look at in the contract. So, but can I just show you 3 other documents, all of which are referred to by the tribunal, which again we say shows MCG going far beyond a payroll administrative company. And the first one is at page 67 of the supplementary bundle. Oh, sorry, I took it out of turn. There's one quoted by the employment judge himself. He sets out the full text of the letter, which is at page paragraph 61 of the employment judge's judgment. So we haven't got it in the bundle because he quotes the full text. And it's the relevant letter when there was an unauthorised absence. And it's at page 280 of the core bundle. You can see it's dated 12th of December 2018. It's from McGinley. Would it be easiest if the court quickly cast an eye over that? The point I'm making is you can see them effectively enforcing obligations, not in an analogous way to an employer. In fact, they expressly refer to your employment, to any employment contract.
Yep.
You'll notice in the 4th paragraph down, Jason, you need to be clear on your contractual obligations for your roster. And then in the next paragraph, we expect all pilots to fulfill the most basic element of any employment contract to report for duties. Then the second letter is where he sought to change his roster of shifts, and that's at page 67 of the supplemental bundle. Yep. 22nd of July 2019. Again, if I could maybe ask the court to quickly read that.
What's your submission on this?
Well, again, it's hardly the sort of thing one expects from a payroll stroke administrative company. They're agreeing, in effectively, to change his hours of work, the whole roster pattern.
Or rather, they're passing on Ryanair's agreements.
Well, whatever it is, it's coming
All
from
right,
there.
that is the way it's structured.
Yeah. If you go over to the page on the second bullet at the top, you have no contractual right for any roster pattern, and we maintain the right to amend or alter your working hours. And any communications had to go to Emma Affenti, who you can see is from MCG, at the last paragraph. And finally, the letter from termination at 13th of January 2020. In light of the time, I won't ask the court to read this one in full, but you'll notice from the bottom of the third paragraph that after the events happened, MCG investigated it. There was then a meeting on the 24th of December. They then decided at that meeting that his behaviour was inappropriate and terminated the contract. And you can see that really in the last paragraph.
Yeah.
So that was all I wanted to show you on the factual documents. So now I come to the cases. And the first and key case I want to show you is Allenby. I realise the court went through that rather quickly yesterday. Now, that was the case applied by the judge here. I'll come on to that. But I should make clear that we're relying on Allenby for all three of the grounds. We're relying on Allenby for ground 1 under the civil aviation regs and the aviation agreement. We're also relying on it for the EU Charter. And we also rely on it for the Agency Worker Regulations and Directive. There are 2 ECJ cases on that directive specifically, for TREEPS, RAB and Omnitel, but we say they speak with one voice with Allenby.
Yes.
So can I begin?
Not call it the TREEPS route, which just means works council.
Well, I'm sorry.
Raw clinic is what it is.
Thank you.
Raw land clinic.
I've done it worse with the Danish ones where I've really got into a mess.
Well, yes, they are very odd because they don't even name the parties.
No, you just get some word that no one can pronounce. But I can pronounce the name of the Advocate General Allenby, which is Geelhoed, which, if you're interested, means yellow hat in Dutch. But anyway,
I didn't know.
Allenby begins at
But you're very distinguished.
yes.
Yeah.
And Allenby begins at page 275. You do have to take some care with this. Sorry, 273. And if we see we begin with Advocate General, who sets out the facts at 9 and 10 at page 278.
Yes. Do you want us to read all that, or?
Well, in the interest of time, I'd ask the court to read it later, but the key point is I think you made the point yesterday as to what happened, my lord. She registers with the ELS. She has to register, that's the agency, on a commission. She was formerly a directly employed lecturer, and then she continues to work for ELS under this agency, triangular relationship. Now, at 15, the Advocate General summarises the various claims. There were in fact two claims, and perhaps I can just explain what they were. One was a claim against the ELS, as you can see.
Paragraph 15.
Yes, paragraph 15 sets out the
Yes, I understand.
various claims.
Whereas it says the claim against ELS is item C.
17. So she brought a claim against ELS seeking equality with a comparator named Mr Johnson, who was employed by the college. And you can see the facts set out explaining that over the page. There were various other claims against the college.
Yes, sorry. 15 sets out 4 claims.
Yes.
The only ones that the reference is concerned with are C and D. That's your point.
The ones against the ELS, yes.
Yeah.
And there's a second claim against ELS at 19.
C is obviously against ELS.
Yes.
Is D also against ELS?
Yes, because if you look at 19, he says against ELS, college and the Secretary of State sought admission to the superannuation scheme. So it's against all three at that stage.
So it's a claim against ELS that she ought to have been admitted to the college's superannuation scheme?
The teachers' superannuation scheme.
Which is a national scheme.
Yes.
Is that right?
Yes.
To which the college, which is why the Secretary of State is involved.
Exactly.
But the college probably is required to, in any event does, sign up its employees to the scheme and pays contributions in respect of them.
If you were an employee.
If you're an employee.
So that was the problem. But the claim is against ELS, and as we'll see when it got...
Well, sorry, but it's against the ELS among others.
Yes, well, I'll come on to how it was dealt with by the Court of Justice, because eventually it was only against ELS and the Secretary of State.
Yes.
And the various questions from the court at 21, perhaps just highlight that for now. If we can then turn to paragraph 45 of the Advocate General's opinion, which is important because it's the paragraph the judge referred to.
Yeah.
And for your note, if you put ET paragraph 103 by the side of it, that's where the judge referred to that paragraph. And for what it's worth, at 48, there's a note that the Commission initially had argued that the employer might be her employer, that the college, might be her employer.
Yes.
But ended up distancing itself from that,
No, I saw that.
based on a legal fiction. And in short, the Advocate General says at 49, there was she couldn't bring the claim comparing herself with Mr. Johnson because there was no common source to the pay. He was paid by the college, she was paid by ELS. That's summarised at paragraph 50, saying there was no single source for the comparison. So she can't rely on the comparison with Mr. Johnson. My lord, you may remember you and I were involved in a case a long time ago about common source called Deffer and Robertson.
Yes.
So this was that. So he ends up at saying
53 is quite interesting. He really makes it clear that he's accepting, as it were, the primacy of the contractual position through,
yes.
through gritted teeth.
Yes.
And saying that there are problems caused by
yes.
the use of agency workers. That's got to be dealt with by legislation.
Yes.
I forget whether it's that very paragraph he says that, but I think he refers to the fact that at that time the agency workers regulations directive had not yet been passed, but was in gestation.
Perhaps you're testing my.
Well, I just read it again this morning, so
yeah.
I may have it may have been somewhere else. It's in there somewhere.
Yes.
I mean, carry on. Yeah.
So then he turns to the second question. So this is about the claim against the. Sorry, give me a moment.
This is the pension scheme claim.
Yeah. On the second question, I should say he doesn't address the question whether she's a worker. So we can then move on to the Court of Justice.
Oh, I don't. That's odd. Normally,
yes,
it's the AG who goes into more detail than the court. But on this
yes,
point,
he does. He does state about whether she can bring the claim, and says there could still be indirect discrimination. But unless I missed it, he didn't actually address whether she was a worker or VLSs. But the Court of Justice does. So now we come to the Court of Justice. And it sets out the facts. Again at paragraph 19, that's page 298. And you can see at 22 to 26, he talks of the various claims. He talks about the various claims against the college at 26, saying those have been remitted for reconsideration. And then the court sets out the other claims. And you'll notice the first claim is against ELS. So 28 is against ELS. That's the one where she's relying on Mr. Johnson as a comparator.
That's the equal pay claim.
That's the equal pay claim.
So that's saying, ELS, you must pay me the same as the college is paying Mr.
Exactly.
Johnson. Yep.
But then the court sets out at 30 what the remaining claims are under the superannuation scheme. And you'll notice by now the claims against the college are not being continued. The claim, sorry, I'll come on to that. At this stage, it's against ELS, the college, and the Secretary of State for the annual.
Yep. So
that's the second claim. Now, and the court sets the questions from the Court of Appeal at 39. And this is a little bit confusing because although you can see the two questions there, and although in the second question we have little Roman numbers 1 and 2, later on the court refers to these as A and B. You might...
What, it refers to
little
Roman 1 and little Roman 2 as A and B, or 1 as A and 2 as B.
It refers to questions 1 and 2 as 1 and 2, but the second question, 2 little Roman 1, it later calls 2A.
Okay, thank you.
And it later calls second Roman 2 as 2B.
Thank you.
And you can see at 40, the claims against the college had settled amicably. That's at paragraph 40.
Yes, so that is all claims. It's not specific to the question of whether she was entitled.
By this stage, the only claim under the second question was against ELS.
Yes.
And the Secretary of State. So the Court of Appeal deals with the first question. This is the comparator one.
So the Court of Appeal, you mean the ECJ?
Sorry, the ECJ.
Yes.
And at 43, it says the article can only be relied upon by workers. So Article 141 is only relied upon by workers. Goes on to say, well, it doesn't quite say same employer, but at 48, it says you have to have a single court source.
Yes, I mean, the structure really is, 43 doesn't really lead anywhere.
No.
Effectively, 43, if you see, even if that condition is satisfied, assuming they are workers,
yes,
they still
exactly.
can't get anywhere. So in this connection, we needn't bother with whether they're workers or not.
Yeah, exactly. No single source claim in the dustbin. Well, it's been settled, really. Sorry, no, this claim hasn't been settled. It's in the dustbin. But then we come on to the second question.
Yes.
And you can see this is where they've referred to it as Part A of the second question, which is why I told you to renumber them.
Yeah.
So Part A is whether can she compare herself with Mr. Johnson. And the first ones at 54 to 55 is no, because you've got no single source, just as we've said in relation to the first question. So that one goes. As regards the claim against the college, you'll see at 56 it says that one goes too, because it's all been settled. So tell me if I'm going too quickly, but the answer to 2A is you can't compare yourself with Mr. Johnson because you've got no single source, and you can't claim against the college because you've settled. So goodbye. So then we come on to 2B over the page. And you'll notice now, because of the settlement against the college, the claims are only against the Secretary of State and ELS. So the college has now gone. So the claim is only, again, it's only about her status while she's engaged through the agency arrangements with ELS. And now the court does address the meaning of worker at 61. So this is addressing the meaning of the worker for the purpose of a claim against the college. ELS, the agency. And I know it's all sidelined, but we get all the familiar mantra.
Well, you say for the purpose of a claim against the college, you say for the purpose of a claim against Article 141.
Yes, against ELS,
Sorry,
and the ELS and the Secretary of State.
And the Secretary of State.
Yeah.
But it's not really addressing the question of who you're employed by, it's a question of your status as a worker.
Well, it is, but if the court was saying you can't be employed by ELS, then obviously they would have said the claim evaporates, because the claim is only against ELS. You have to be a worker. You're not a worker of the Secretary of State. The claim only gets off the ground if you're a worker of ELS.
And if she'd been a worker of the college, they wouldn't have done the first claim.
Exactly. If you'd been a worker of the college, the claim would have been easy. They would say, well, you can compare yourself with Mr Johnson. So this is for the purpose of a claim of being a worker of the college. Of the ELS, I must stop saying that. Lack of sleep. And you can, I won't read all of this passage because it's obviously important. And I'll come back to what we say you derive from all of it. But this is only, you can see at 70, they say that the legal relationship with the other party is of no consequence. 71, the factual called self-employed doesn't matter.
The legal relationship with the other part, providing they're a worker,
yes.
The nature of the legal relationship with the person for whom they are a worker,
yes,
is of no consequence.
Yes.
Yeah. I.e., that is entirely the self-employment issue.
Yes. Yeah, you can't be full self-employed. 71, the question is, and this is for the purpose of a claim against being a worker of ELS, is your independence merely notional? And 72, and that's the critical paragraph, and you'll notice it's talking about, in the case of clients who are vis-a-vis an intermediate obligation.
What does vis-a-vis mean in that context?
Well, in relation to.
I actually looked, rather oddly.
I did as well.
I looked up the French.
I looked it up and I forgot
which
what
isn't vis-a-vis. The French is à l'égard. But it must mean, I suppose, in relation to, yes.
Well, it must be, because that's all the claims. She's got no other employer. It's only against ELS. And that's what Allenby is telling the domestic court to do. And they are saying you look at the extent of any limitation on their freedom to choose their timetable, the place and content of their work. And even though in that case they had no obligation to accept an assignment, that was not fatal.
Is it fair to say that this passage assumes that she is a worker of ELS, not the college, but there doesn't appear to be any argument by anybody that she was in fact a worker of the college, and the argument was really about whether she was a worker at all rather than an independent contractor?
Well, the argument against the college had been abandoned. You'll notice the commission initially.
It's a bit like this case,
yes,
where there's a claim against the college, sorry, a claim against the ELS, I'm doing it now, but not the college, just as we have a claim against MCG, but not against Ryanair.
Yes.
But is my summary right or mistaken in some way?
Well, I hope. I'm always scared of agreeing with judicial summaries. But,
very wise.
As my lady Elisabeth Laing has pointed out, if he were an employee of the college, the claim would have been very, very easy.
Yes.
If she were, it would be very easy because you'd had a direct comparator.
So, I mean, certainly I accept it is assuming that
so this is
she is a worker
of
ELS.
Of ELS, exactly. Otherwise, this claim doesn't get off the ground. So that's what, and in a sense, it's interesting. The Court of Justice focuses very much on what the workers' restrictions on the worker autonomy. Is this person an independent undertaking, or are they a worker? But and if there's any doubt that this is about ELS, well, I
don't think there is any doubt it's about ELS. The question is its weight as authority in circumstances where the alternative is not being considered.
Well, I think the Advocate General said the Commission was right not to pursue the.
Well, all right, when we're looking at the court.
If the court was going to say you can't be a worker of ELS because you're a worker of the college,
well,
it would have said so. And we'll see.
But nobody was arguing that.
Well, we'll see in Betriebsrat and Omnitel, both again agency cases, where the court says exactly the same thing and says.
Well, fine. That's perhaps. Yeah. I agree, Alan, it's an important case. We ought to analyse it. You've been very helpful in enabling us to do that. But I think the point we've reached is that there are helpful things into it, but it's not directly in point.
Well,
because of the way the litigation went.
Well, we say it is directly in point because that is saying, vis-a-vis an agency, here's the question you ask to decide if someone's a worker. And that's the question the employment judge asked and answered.
I think Mr Brown said that this case shows that the agency can be the employer, but not that it necessarily is.
Yes, and so it tells the National Court to ask the question at 72, which is what the judge here asked himself, and which he answered. He expressly cites in a footnote paragraphs 71 and 72 of Allenby. And if you want further confirmation that this is a claim against ELS, if you go to legal consequences at paragraph 77 and following, you can, at the bottom, you'll see again we get reference to the words merely notional. And then at 80 again, turning section as far as ELS is concerned. So again, underlining this is for the purpose of the claim against ELS. Can she bring the claim against ELS in relation to exclusion from the pension scheme? And 81 is very important. So this is an argument for ELS. Are we bound by the non-admission to the pension scheme? And can I ask you to read 81? Now, the reason why I say 81 is so important, because it's saying where you have a national legislation discriminating and excluding workers, the consequences are this is binding not only on the public authorities of social agency, but also on the employer concerned. Who can that mean except ELS? Because this is addressing whether ELS is the employer for the purpose of this claim and saying, yes, you are. And it underlines it at the end of 82 after referring to another case I'm not going to try and pronounce.
Rinakeen.
Where again it says female workers can nevertheless invoke Article 1 against their employer.
Doesn't really face up to the difficulties. If this is a pension scheme for, I suppose the way it would have to work would be saying ELS is in fact employing teachers, therefore it must be admitted to, it must be possible to admit its workers to the pension scheme.
Yes, the problem was under national law you had to be an employee with a contract of employment. So the argument was that's discriminatory because
I see. So if ELS as an agency, the assumption of it was that if ELS as an agency had employed its workers, which you can do with agencies, under a contract of employment, it would fall within the terms of the pension scheme.
I think that's right. Yes, exactly.
Yes, I see.
So the discriminatory condition arose because women were saying we're disproportionately grouped in the category who are workers but not employees under national law.
Anyway, there we are. Thank you. Anything else on Allenby?
No, just to say we derived 6 points from it. Firstly, the claim is about receiving pay from her employer.
Sorry, say it again.
The claim was about Article 141 and receiving pay from her employer. And that here, Mr Lutz received his pay from MCG. Secondly, the fact of direction and control by the college was not fatal to the finding that she was a worker employed by the agency. If it were, the Court of Justice would have said so. Thirdly, nor was the fact of working for the hirer, the college, whatever that means, fatal to employment by the agency, ELS. If it were, the Advocate General Court would have said so.
You say whatever that means. I think what working for the college means that the college gets the benefit of the services.
Yes, well, for, as you know from Uber, is a pretty opaque term. Despite Mrs Allenby being directed by and working for the college in all her activities, the court is explicit she can bring a claim against ELS in its capacity as employer.
Is that number 4?
Yes, sorry. 5, no suggestion the college was her employer because it directed her and was working for it. And I adopt what my lady said, that if so, this case would have been very easy.
Well, it might have said it was terribly easy. It said, unfortunately, it's been settled. So
yes, why did you? Yes, so you've wasted our time.
Oh, I'm sorry. My observation is not meant to be quite as helpful to you.
Oh well,
my observation was it might have been very easy, but they had no occasion to say whether it was easy or not because it had been settled.
No, but there's no indication anywhere in the Advocate General or the Court of Justice that the real employer here was the college. So she's brought the wrong. She shouldn't have brought a claim against ELS. And sixthly, the key issue is to decide whether she's an independent provider of services on the one hand or a worker as regards the claim against ELS. And the question is her independence entirely notional because did she not have freedom to choose her timetable, place and conduct of her work?
Right.
So now we turn to the Employment Tribunal briefly, and I will take this quickly because I'm conscious of the time. Page 290. And my lords and my lady, forgive me for going quickly. It is under the heading temporary work. We accept that's the wrong heading. Structure is always fundamental to writing. But he refers to Allenby at 102. At 103, he refers to paragraph 45. That is a mistake. It should be paragraph 45 of the Advocate General, the one I've already shown you. And he says, just to summarise, when you look at it, he's in just the same position as Mr. Allenby, as Ms. Allenby. Forgive me for paraphrasing. At 104, he looks at the questions that he's required to address in accordance with Allenby. If you look at footnote 41, that's where he's directed himself to paragraphs 72 and 71 of Allenby, and asked whether Mr. Lutz's independence is entirely notional. and he finds it was. And he looks at all the relevant factors at 104.1 to 104.14. Can I say that even though he refers to Ryanair and they, some of these matters he seems to have addressed they compositely. For example, over 104.1, he was in fact told by MCG, that's paragraph 33. 104.2, that was told to him by MCG, C35.
So what was the reference for 104.1? 33.
They told him, I think this is again...
Sorry, which one are you now moving to?
104.2.
Yeah.
In fact, that was MCG, C35 and 36. 104.3, they again, that was MCG, C39. 104.4, apologies, I haven't got the reference, but I think that was MCG as well.
Must be, yeah.
104.6, that is MCG, he does mention it. 104.7, well, query who dictated the terms, he had no choice in them. 104.8, Ryanair told him what his base would be. Well, that was true, it was Ryanair's decision, but it was MCG who notified him. See paragraph 73. 104.9, yes, his duties were rostered by them, but as we've seen, it was based on his contract with MCG. Without that, there's nothing, no obligations. 104.11, he was subject to discipline, yes, but that was, as we've seen, MCG were involved in that process, investigated, held a meeting, and disciplined him. 104.12, he was paid the amount they decided. Well, query who that is, but it's certainly in the contract, it's MCG. And 104.13, he had to apply for holiday. Well, in the contract, that's set out in his contract with MCG. We say, in light of the undisputed fact he was an independent he wasn't an independent undertaking, that MCG wasn't his client or customer, and the undisputed fact he had no freedom to set his hours, the content of his work, or the place of his work, there is no other possible conclusion applying Allenby than he was a worker.
Doesn't the fact that they is used so loosely in paragraph 104 suggest that this paragraph is not addressing whose worker he is, but whether he's a worker as distinct from an independent contractor?
Well, with respect, my Lord, I think that's exactly how the Court of Justice is doing it in Allenby. Because the Court of Justice is saying, we want you to look at whether your independence is notional vis-a-vis the agency ELS. That question, you don't partition, as it were, bits of duties owed to the college and bits owed to the agency. You say, looking at this in the round, are you an independent undertaking or not? Because the focus is very much on the worker's position as an individual rather than who's the employer. And there is only one answer to that question.
Yes, but then that leaves the question, who are you a worker for?
But the AWD doesn't say who you're a worker for.
Well, we haven't brought us there, have we? You've been going from the case law.
All right. Well, I don't want to press points more than I have to, but we say you can't. There is no.
You're banging in the nails very hard on the part of the case that isn't really the difficult part.
Well, I'll come to the difficult part then,
right,
my lord. So that's we say if we're wrong on that. The EET is entitled on the facts that we've seen to reach the conclusion. And we endorse what the EAT said at 146 to 147 and 153 to 155 on how the tribunal correctly applied Allenby. Yes, Mr Britton points out, sorry, that there was an actual finding he was working for MCG at 122.2.
Yeah, of course.
So now the three grounds then. So now the difficult part.
Right. And so under that heading, you'll be coming to your two other European cases.
Yes. So I'm going to frame this dealing with ground 1 in relation to the aviation regulations and directive, ground 2 in relation to the charter, and ground 3 in relation to the agency worker directive. So first, the point my lord raised yesterday about the problems of the CAT duties applying to someone who's not, to an agency in the position of McGinley.
Yes, not in control of the workplace.
Not in control.
Of the working arrangements.
And there's 4 points really that we make.
Hang on one second. Yeah.
Firstly, we say that under EU law, in an agency relationship, the position is clear, the employment relationship is with the agency. And I've already shown you Allenby, but now, can you just note, we say that is confirmed by, sorry, I keep saying Betriebsrat, and on
Roland Clinic. Yeah.
Secondly, the aviation agreement, which is going to be my focus, applies to those employed by an undertaking. It doesn't say employed by an undertaking which operates an airline. Thirdly, if necessary, we will say the duties on the employers are not delegable, just like common law health and safety duties. Suppose, for example, Mr Lutz did have a contract of employment with an agency. So there was no doubt Mr Brown accepts that's possible, and they sent him to work to Ryanair. We would say they, as employer, would then owe the duties. They're not delegable.
How would they comply with the duties?
Sorry?
How would they comply with them?
Well, they have to ensure that the person to whom he's being assigned is complying with them.
Yes. Okay.
Or suppose an employer, the same thing might happen if an employer seconded one of its employees to another area.
Yes, absolutely. This is not peculiar to what are conventionally regarded as agencies. Or you often will have a company in a group in which the employees are owned by company, employed by company A, and the business is run by company B, and there's some internal accounting for costs.
Yes.
And you can have mixed workforces where people come, they're all in, there's not an agency issue, they're all genuine employees, but of different companies. So this is a very general problem, and I'm just trying to find a good, correct conceptual answer to it.
Well, we say they're non-delegable. It makes no difference that you've got an EU employment relationship rather than you're an employee. The duties apply.
The agent would just have to ensure compliance with the regs by the end user.
Yes.
And be liable if the end user lets them down.
Fourthly, can we just look at the directive itself, the aviation directive?
This is fourthly, is it?
Yes. If one turns to the directive, which is really what this is about, because it's all about the autonomous EU concept, and it's at divided 13. Oh, sorry, yes, 13.
Sorry, which divider did you say?
Divider 13, page 114. Now, you'll notice under Clause 2 defines, 2.2 defines who a crew member is.
Sorry, just one moment.
It's the aviation, it's the actual agreement, which is at page 114. So it defines crew members employed by an undertaking. I'll take them quickly, but you'll notice that when it comes to the actual concrete obligations...
I'm so sorry, where's the definition for crew members?
2.2, clause 2.2, mobile staff employed by an undertaking. When it comes to actually how a member state gives effect to these, the duties themselves aren't very specific because, for example, you'll see under clause 4, they've got to be entitled, they're entitled under clause 3 to holidays. That's the one we're worried about. Doesn't just says entitled to it. Under clause 4 talks about free health assessments. Then says have safety and health protection appropriate to their nature of their work in 5. Clause 6, then you have to have measures. The only clause that refers specifically to an employer is clause 6, that the employer who intends to organise work according to a certain pattern takes account of the general principles of adapting work to the worker. So that one is specifically on the employer. And we would say in an agency arrangement, yes, that duty is owed by MCG. That if they go, where they're organising his work, they owe that where they are intending to organise the work, they owe that duty to adapt it to him. In a sense, they did do that here because I've shown you the letter where they actually changed his shift pattern on request by him. And then various other things about annual working time over. But it doesn't actually say how the member state gives effect to these. So it could do in a variety of means. And it wouldn't have to impose the obligation on the employer. It could say, some of these obligations we're going to give effect to it in a different way. You are within scope, you're employed by an undertaking, but we may give effect to these by different means.
So, well, it could have adopted the model, which it did for the Agency Workers Directive, sorry, Agency Workers Regulations, of imposing some liabilities, well, of providing for a right and then splitting the Hofeld, having somewhere else in the, because this is, I'm right, we haven't looked at it yet, this is how the Agency Workers Regulations work.
Yes.
Lots of rights provided for, and then a section saying who's liable if these rights are not accorded, and saying might be the end user, might be the agency, might be both, and room for apportionment, whichever is sued.
And to some extent that is done under domestic law. There's a whole raft of regulations about civil aviation, which, thank heavens, we're not looking at. But when it comes to this, yes, you're right, they could have done it in those ways.
But for reasons we don't know, it didn't.
No. But the point we make, and this is our final point, 5th, the specific right we are seeking to enforce is clause 3.
And that's easy, you say, because...
We say that's easy. We are not seeking to enforce rest breaks or anything else. We are seeking to enforce the fundamental social right in clause 3.1. That right is directly effective, see the Court of Justice in Dominguez. We say in relation to that right, the only logical party in an agency relationship is the agency. And that is the right you have to protect via MAR leasing.
Hang on 1 second. Okay. Why via MAR leasing?
Because you have to achieve the result that the directive requires.
Yes, but I mean, maybe we haven't even looked. Nobody's taken us yet to the provisions, or you haven't taken us yet to the provisions of the regulations. Maybe we don't need MAR leasing.
Well,
clear on the face.
You don't, because all the regulations say, the relevant regulations.
Yeah, okay, sorry, I was wondering, your reference to MAR leasing suggested the regulations were...
No, I'm not suggesting there's any heavy lifting. There's no heavy lifting. Because we say...
Right, okay, anyway, so that is the... So the point you're making, your fifth point is, well, frankly, the rest breaks point is all for another day. Slightly unsatisfactory, perhaps, for us to make a finding about how it works for one bit of the regs and or the directive without having a coherent structure for the lot.
But my lord, and forgive me citing authority which isn't before you, that's a perfectly possible result to reach as a matter of statutory interpretation. See Hurst in the Supreme Court, where they said when you're interpreting a provision in order to give effect to the Human Rights Act, you can adopt a particular interpretation to give effect to that right, which doesn't apply in other contexts.
Yeah, I know that, but that's not quite analogous, is it?
Well, all we're saying is to give proper effect to Clause 3 of the Aviation Direct Agreement in an agency arrangement, the only sensible employer is the agency.
Okay.
I've shown you already the clause in his contract. It's the agency that releases him from the obligation to work, because it's under his contract with it that he owes that obligation. So it's the agency that gives him leave.
So effectively what you're saying is that the agency already in its agreement provides that that he will not, there will be one free month. That effectively will be his annual leave month.
Yep. And
the only difference is he has to be paid for it.
He has to be paid for it. And we say it is well, I don't want to put it too highly. I've done that before and fallen foul of it. We say it's absurd to impose that obligation on Ryanair, because he's got a right to his normal remuneration for annual leave. What on earth is supposed to happen when he's taking a day, because he was also entitled to ad hoc days, he takes a day of leave? Does the obligation to pay magically switch from the agency to Ryanair?
You're emphasising the obligation to pay, saying if it's all about paid annual leave, then you ask the question, well, who's responsible for paying him?
Yes.
Which, in this case, is the agency.
Exactly.
Yeah.
So the duty is normal remuneration, which may have to include supplements, but the person who knows that is the agency.
Yeah, I mean, this is an oddity, which I think I alluded to yesterday, about the whole. Although this is under health and safety legislation, and the meat, you might think, of the obligation is concerned with actually arranging work, this particular obligation, which is the nature of this claim, is a financial one.
Yeah.
But as you can tell, I'm slightly jibbing at the idea that someone can be the employer for the purpose of the financial obligations, which are parasitic on the primary working time obligations, without also being the employer for those purposes. As I understand, your primary position is no problem. We're happy the MCG should be the employer for all those purposes. But if that does create great difficulties, fallback position, certainly the employer for these purposes.
Yeah. And fallback position, which I maybe come on to next, fallback position 2 is, if all of that goes in the dustbin, then we just rely on the Charter.
Yes.
We just rely on the EU Charter because none of these policy difficulties arise in relation to the Charter, because the Charter right is only to paid annual leave.
Yeah.
Now, I'm going to have to deal with this quickly.
You haven't yet taken us to Omnicom or...
I'll come to those very briefly. I think Mr Britton has allowed me till 12:30.
Oh, has he? Right.
But I can already feel him getting twitchy. So can I deal rather...
And I suppose the hirer may not know what the worker gets paid. It knows what it pays the agency, but it doesn't know how much of that ends up in the agency's pocket. I mean, in Ryanair's case, it may be they have a pretty jolly good idea, but in theory, that would be the way the structure works.
Yeah. And remember, this isn't just agency workers in this context, it's agency workers generally, in a sense. And the person who pays is the agency. The EU right is to normal remuneration. Who can owe that obligation other than the person who pays?
Right, I see that.
So,
I mean, just to spell this out, make sure I've understood. Ryanair will certainly know what hours he's flown.
Yeah.
But they won't know in principle. I'm sure they know in practice, but they won't know in principle what the deal is with the agency as to what hourly rate he gets.
Well, and as you may recall, my lord, there are fiendishly complicated provisions in the Employment Rights Act on a week's pay, which you have to apply for the purpose of working time and normal remuneration. How's Ryanair supposed to apply those? You know, the agency's got the records, knows what's been paid. They've got the records. They say, yeah, we'll pay you.
My fault for raising it. I'm not sure there's a problem in practice. The fiendishly difficult bits relates to when you worked, which Ryanair will know. The bit that the hirer will know is the rate you pay, which is not difficult. That's just arithmetic.
I'm not...
I say the bit the agency will know.
With respect, sir, my lord, there's been several cases gone to the Court of Justice about normal remuneration and which supplements are in and out. It's not...
Let's not go there.
Let's not go there.
Especially as time is short. Okay, where are we going next?
Like the Charter. So we say none of these problems arise in relation to the Charter right. Now, if you'll forgive me, I'm going to have to deal with this very quickly. But first of all, there's no dispute the Charter is directly and horizontally effective. Can I just give you the references? See the Grand Chamber in Max Planck and Shimizu 74 to 80. Page A742.
What paras? Sorry, Max Planck.
Yeah.
What paras?
74 to 80. There is just one. No, I do have to show you it. Apologies. If you could quickly turn to page divider 39, which I think is in volume 2. And it's at page 4741. And there's a long thing about explaining at 74 to 76 how it's enforceable. You can see at 78, the court says it confers a right on individuals that they can rely on in private disputes effectively, without, therefore, Article 51 of the Charter precluding it, which I think Mr Brown may be showing you later. And 79, it entails, by its very nature, a corresponding obligation on the employer. So that's your Hofeld point.
I think it was initially your Hofeld point.
Well, and I'll come on to the 4-week point shortly, but it's common ground we can rely on it directly because the claim was brought before IP completion date. See our skeleton para 14.
And just so that if this cause of action had arisen after IP completion date, this argument would not be available to you.
No, because the Charter ceased to be part of UK law. But because the claim...
So it's not a point on which you'd rather win, looking at the wider interests of the contracted pilot workforce.
Well,
no, all right, but I'm just trying to think.
Yes.
Yeah.
The right in the Charter applies to exactly the same worker concept as the WTD. And again, I'll just give you the reference. That's Fennell, paragraphs 25 to 27.
Fennell, yeah.
Fennell,
Yep.
page A647.
Which paras?
Paras 25 to 27.
Yeah.
So if he's a worker, as we say under Allenby, he's a worker for the purpose of the Charter.
Yeah.
Fourthly, and this is where I'm afraid what you've been told is completely wrong, the Charter does guarantee a minimum right of 4 weeks. And can we begin with Advocate General Bowe in Bower, which was one of the authorities handed up yesterday. I think it's at divider 59.
Right, so it's gone in the back of the authorities part.
Yes.
Okay.
I think we've got dividers for that. Have you got a page number?
Oh yes, it's 11. Give me 1 second.
So it's 1138.
Thank you.
1145 is the relevant extract from the Advocate General.
Okay, just give me 1 second. Very well, and
So you'll notice at 88 and 89. So 88, he says the directive is based on Article 7, and then he explicitly says the Charter guarantees to every worker the right to an annual period of paid leave of at least 4 weeks. And I've got to tell you this to win a bet. That's referencing an article by Professor Alan Bogg, footnote 93.
have we got that?
Yes, the footnote.
We've got the footnote. Have we got the article?
No, you haven't got the article. In fact, since I've rewritten it with him, but the footnote is at, you do have 93, where it refers to the article.
Yes, I see.
So, explicit statement by the Advocate General, 4 weeks is guaranteed. We then come to Sekeros, and I'm going to have to summarise the facts of this quickly. The Advocate General is at D42.
What case is this?
This is Sekeros, the one that you were taken to yesterday by Miss.
What's the whereabouts in the bundle is it?
D42, so it's in bundle 3.
Yep. Tab 42.
Tab 42, I do apologise.
So the name doesn't ring a bell, but I'm sure it's just interesting. Oh, Carrero Sequeiro.
Yes.
Yes, sorry, yes. Yep.
And just to give you the background in this was where the staff leave was reduced from 42 to 24 days.
Right.
So they still had more than 4 weeks.
Okay.
And the General Court said that's a breach of Article 31 because you're reducing their leave.
Yep.
The Advocate Generals and Court, to summarise, both say no because they say the right in the Charter is only to 4 weeks. And we see that, first of all, in the Advocate General at paragraph 62.
Yep.
And we see it then confirmed by the court at 113 to 117. Now, this is at divider 43. I'm skipping quickly, but if I can just tell you what the structure of the Court of Justice's reasoning is. If you look at page 817.
Yes, we're looking at it.
First of all, at 1112, it says the Charter is based on the Working Time Directive. That's according to the explanations.
Yes.
Secondly, it says at 113, the right is also derived, according to those explanations, from other instruments, such as the European Social Charter.
Yeah.
Thirdly, at 114, it says the European Social Charter at the end guarantees the provision of a minimum of 4 weeks of paid annual leave. And 117, which is probably the critical one, it says, referring to the Working Time Directive, the minimum duration is entitled by aligning itself in this respect with the period laid down in Article 2 of the European Charter, i.e. 4 weeks, which also underpins the fundamental right to paid annual leave affirmed in Article 31.2 of the Charter. and says Article 7.1 is only gives concrete expression to that fundamental right. In other words, the Working Time Directive is only giving concrete expression to the fundamental right to 4 weeks annual leave in the Charter based on the European Social Charter.
It's interesting that it's an article of the directive that precedes the Charter by several years.
I know. Yeah. Well, it is explained at length by Advocate General Bowe, but luckily we don't have to.
Yeah.
So in other words, the Charter itself, because of its origins in the European Social Charter, guarantees everyone 4 weeks. And you can see that's why they lost at 118, because they were entitled to paid annual leave of more than the minimum. So they lost. But if their leave had been reduced below the minimum, they would have had an enforceable right under the Charter.
I understood Mr. Brand to be saying that the Charter point, that the effect of Carrera Sequeiro was that the right was insufficiently specifically spelled out. You just say that's not...
Completely wrong.
It's just not what it says.
Completely wrong. So it's
Okay,
an
right,
enforceable...
well, fine.
Yeah, both Shimizu, Bauer, and this case confirm it's a right enforceable, specific right enforceable horizontally, and it guarantees a minimum of 4 weeks.
Okay, right.
So
Anything else on the Charter?
no problem for the employer on that. So finally, Agency Workers Directive. And can I just begin with the Agency Workers Directive itself, because this is ground 3. That's at divider 15. Begin with scope at page 154, Article 1.1. We rely on this generally to show the employment relationship in EU is with the agency, because you'll see this directive applies to work with a contract employment or employment relationship with a temporary work agency or assigned to work under.
So where are you reading from?
Article 1.1.
Oh, Article 1.1. So I was looking for recitals. Yep.
In other words, this directive, in common with our submissions, assumes the employment relationship is with the agency, notwithstanding you're assigned to work under the direction of the hirer. And secondly, Article 2, for the same end, the purpose of this directive, blah, 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 and then 5 lines down, and by recognising temporary work agencies as employers. So the same theme, that the agency, the temporary agency worker is the employer. Then the definition of agency worker in our Article 3.1c assumes exactly the same: a worker with a contract of employment or an employment relationship with a temporary work agency. And you'll see the definition of a user undertaking, Article 3.1d, means any natural legal person for whom and under the supervision and direction of under whose supervision and direction you work. Well, if working for the hirer took you outside of scope, there would
Got the point.
yeah. So, Betriebsrat Ruhrland Clinic, the last two authorities, at divider 38. this is the one where the nurses who were members of an association were assigned to work for Ruhrland Clinic. Now, in a sense, there was a reasonable argument based on the directive that they might not be workers, because the directive itself, just for your note, says in Article 3.2 that the definition of worker is without prejudice to national law as regards the definition of pay, contract of employment. So it contained one of these clauses saying the member state appeared to have a discretion.
Courts sort of ignored that.
They all ignored, exactly. And you can see, if I can just show you the Advocate General at 10.
I'm not going to ask you how to pronounce him.
Yeah, I'm not going to pronounce that one.
Someone did once tell me, but...
Is that Finnish?
Sorry?
Is that Finnish, the language?
He is... no, he's Norwegian. Not Norwegian, Swedish, I think.
Okay.
Anyway.
And you can see the Advocate General at 10 and 12 sets out the facts. And you can see at 10, when the nurses were assigned, they were under the functional and organisational instructions of the clinic. So that's 10. So just like Mr Lutz. 12, you can see again at the end of 12 that when they were assigned, they received the same remuneration as directly employed and are subject to rules and conditions of employment that are virtually the same, exactly the same as, just like Mr Lutz, same as directly employed. The Advocate General cites all the familiar mantra of being a worker at 24 to 26. And 26 is the one on which we place particular reliance.
Yeah.
So you'll notice he gives a very strong steer that they are workers, even though they're under the direction and control of the hirer.
Yes, but the question is who they're working for.
Well, the agent. The only claim here is against the agency.
No, I understand that, yes. But the issue with which we're concerned didn't arise. They weren't claiming to be workers for the Ruhrland Clinic. The issue was just the Ruhrland Clinic said, trade workers' council said we don't want these people because they're not coming temporarily. Then they're coming permanently. So there was no. The issue with which we're concerned wasn't directly involved here.
Well, it is because remember, ground 3 of the appeal is that we're out scope of the agency worker directive. That's ground 3. He's not a worker.
I get confused with all these grounds.
Well, ground 3 is he's out of scope of this directive and these regulations.
Yes, but you were also relying on this case for the purpose of your earlier, and that's really what I'm focusing on.
Yes, sorry, if I'm relying on it as being one with Allenby, but also critically we're relying on it for ground 3.
Yes, I see.
Because this is directly on ground 3.
Yeah. Okay.
And I haven't got time to deal with it, but the Advocate General goes on to deal with it. Well, is she excluded? I think it was she, excluded because of all the provisions?
Well, it's no she, it's the whole point. There aren't any parties.
Yeah.
They, the nurses, who presumably could be either sex.
Are they excluded because of the discretion the directive appears to give to a member state? And as my lady has just said, he says no. Referring, for example, of the principle of equal treatment. And the Court of Justice is exactly the same. You can see at 27 to 29, where that's dealing with the first issue, was she a worker, citing all the familiar cases like Denosa, which echo what's said in Allenby, and in short terms, I haven't got time to say more, says they are within scope. And then they do the same exercise, paragraphs 30 onwards, and say, well, even though there's a discretion under Article 3.2 because of the importance of the principle of equal treatment you're in. So for the avoidance of doubt, we say this case is directly on point and conclusive in relation to ground 3. And the final case is Omnitel, which is a post-Brexit case.
So this one isn't. This one is not post-Brexit.
Yes, that one isn't. This one is.
Yeah.
Omnitel is at apologies. Divided 52.
Yeah.
Facts briefly are that the Ms LM was engaged by someone called Leadmarket and then assigned to work for Microsoft. And the issue arose whether Leadmarket was a temporary work agency for the purpose of this directive. And really the only passages I want to show you are firstly paragraph 40 and 41, where they talk about the importance.
Is it in the court or the AG?
The court, this is.
Yeah.
It's at page 1013, where they talk of the importance of the directive protecting workers. And then the second question is concerned with the status of the worker. And at 56 and 57, the court talks about triangular relationships and what happens, and says that it's really 57. Perhaps I can ask my lord and my lady to read that.
Yeah.
And the short point I derive from 57 is when you're assigned to work for the hirer under its control, direction, or working for it, however you want to describe it, you retain an employment relationship with the agency. And you can actually see at 59, well, the agency did do a few things. It referred to it approving leave, etc. And it said, well, it's not that unusual for the agency to carry on doing some things. It was still under the supervision and direction of the user. And therefore, even though the agency does some things. And once again, that's pretty analogous to here when it comes to ground 3. Because the MCG did do some things. Mr Lutz was under the direction and control of the hirer. He's within scope. And the very, very last point is domestic interpretation relevant to ground 3 of the agency worker regulations. I think my lord raised this point yesterday, but I don't know if the court noticed the words working for were actually removed from the original draft of the agency worker regulations. Yeah, I'm going to go for that. So we say, if necessary, domestic law can go further than EU law, and here it has gone further. If necessary, we don't say it is necessary, because if you look at the if you look at Regulation 3 at page 38, you can see under 3B2, it talks about any other contract with the agency to perform work or services personally. It doesn't say for the agency. And those were, the original draft did say for. Those words were removed by SI 2011-1941, which is at page 74. And if you look at the explanatory memorandum to the changes, which is at page 55, divider 55.
Divider 55.
Divider 55, yes.
Yeah.
Page 1094. You can see at 7.2 when they talk about the amendment to Regulation 3 has been made to avoid any unintended narrow construction of the part of the agency worker. So they remove the words for precisely in order to show that a wide group of people were within scope. And I'm afraid I have to finish with a very cheap point. If you go back to Mr. Brown's grounds of appeal on ground 3, the ET and EAT were wrong to conclude.
Where are we looking? Where are we?
Sorry, page 15 in the core bundle.
Yeah.
I may have missed this. The EATM were wrong to conclude that C was a crew member, quote, employed by MCG for the purpose of AWR. I don't think those words even appear in AWR. So it's not a promising start to a ground of appeal to refer to a statutory provision that doesn't exist. Is there anything else, my lord?
Well, I think this doesn't come under this ground. I probably should have asked you earlier. Do you have anything to say about Mr. Brown's point about Regulation 36 of the Working Time Directive and the absence of any equivalent in the CTAWR?
Yes, well,
CA, whatever it is.
Well, first of all, we say if we're right, it's dealt with in our skeleton. Perhaps I can just give you the references to that.
Okay.
But I'll just say a couple of things about it.
Give us the reference skeleton first.
Well, perhaps while Mr. Brittenden's looking for that, I can just tell you briefly what we say.
Okay.
Well, we say, firstly, if we're right on the EU concept, we win. And it doesn't matter what Regulation 36 says.
Right.
Secondly, it only applies where there's no workers' contract between the individual and the agency. It was passed in 1998. We say it was a catch-all provision. It may, as my lord indicated yesterday, have been done because they thought that was something like that was required under WTR. But remember, at that stage, the precise position of agency workers and workers, in fact, how it worked under domestic law wasn't very clear. But we say it provides no basis for inferring catware aren't intended to protect members of cabin crew engaged by an agency. In fact, the purposes are all the other way.
Okay.
And finally, and this really is finally, if you don't...
No, I thought Mr Britton was going to give us the reference to where it was in the study.
Paragraph 52, page 114.
Thank you.
Finally, if you'd asked, we say, applying WTR to Mr Lutz, is he a worker for the purpose of WTR, which adopts the cognate definition as section 230, we'd say, yeah, he doesn't even need 36.
No.
He's providing personal services. Someone who's not his client or customer of his, he's not operating an independent business. He's a worker. He doesn't even need it.
Okay. Unless my lord and my lady have any questions for you, we better get on with Mr Britton.
Thank you, my lord. And my lord.
So you're dealing with temporarily?
Yes, my lord, dealing with temporary. If I can just perhaps start by signposting what I'm going to cover. There'll be a few general propositions by way of just general overview, responding to all of the grounds. Secondly, I'm going to address the court on the context leading up to the directive on temporary agency work. And then, in responding to ground one, that is the meaning of temporarily, propose to address the call by reference to three judgments of the European Court, KG, ALB, FIS, which we haven't looked at yet, and Daimler.
Okay.
And hopefully, those three authorities, or my ultimate submission is going to be that those three authorities also address and dispose of Ryanair's ground 2, that is, do you have to look at the nature and purpose, and McGinley's ground 4, the tribunal focused on the wrong contract.
Okay.
So by way of overview, position on behalf of Mr Lutz, it can really be distilled to three propositions. The first is, for both the purposes of Article 3.1c of the directive and 3.1a of the regulations, the focus is on, and must be on, the individual worker and their relationship with the agency. The focus is not on the relationship between the agency or the hirer. And also the focus is certainly not on the nature of the work to be done. And contrary to what Mr Bowers submitted, it's not about or limited to precarious work. So that's composite of proposition 1, but proposition 2, and this is really the central submission, it's a binary question as to whether or not a worker's assignment is either permanent or indefinite or temporary. And
hang on one second.
A pause. Apologies. So to repeat, it's
binary question whether it's on the one hand permanent stroke indefinite or on the other hand temporary.
Temporary. And there is no, in accordance with the case law, there's no intermediate middle ground of longer term agency workers who fall into a wilderness of rights. They're not covered or protected by the directive or the regulations. So as a consequence, that is the binary statutory question of construction, if I can call it that. It's not whether the worker was assigned short term. And the third proposition is this: to decide if a relationship between the worker and the temporary work agency was with a view to them being assigned temporarily, the focus has to be on what was intended, firstly, when the worker entered into the contract with the agency, and secondly, when the worker was assigned to the end user under that contract. So that must be the correct focus.
Well, hang on, that's two focuses.
Two focuses. I appreciate that. In this case, well, I agree it's two focuses. That's because you may well have a situation where you've got an umbrella or 0 hours contract between the worker and the agency. And then there may be ad hoc or sporadic supplies.
I don't quite understand that. I mean, are you going to develop this point later, or
I will develop it. I will develop it later.
in that case, I'll wait and see.
But I suppose the key point is, perhaps not overcomplicating it, for the purposes of Mr Lutz's case, the contract that he entered into with McGinley MCG was for a fixed term supply of 5 years, which was temporary. In relation to the facts...
Hang on 1 second.
Lord, I'll make good that...
But the language suggests that I think that you focus on each supply.
Yes.
And here, although there's a 5-year contract, he's not been supplied for 5 years.
No, not on every day, but that was the intention, that he would make himself available to be supplied.
Let's see.
But my Lord, at that point, I'll address you on that further when we come to
let's wait, yeah.
ALB fees. In terms of the facts, just really 2 points to add to what's already been said in relation to this. We know that Mr Lutz entered the contract with MCG on the 7th of May 2018. What you haven't been taken to yet is 2 pieces of correspondence subsequent to that. If I can briefly invite your lordships and ladyship to look at 2 pieces of correspondence in the supplementary bundle, pages 65, 66, it's dividers 13 and 14. What we have at page 65, correspondence from MCG, dated 10th of July 2018.
So sorry, I've got slightly behind, but it's a supplementary bundle.
Supplementary bundle, my lord, and it's tabs 13 and 14.
Yeah.
So page 65, letter from MCG, 10th of July 2018. I should say, by way of context, from recollection, this was supplied when Mr Lutz applied for some kind of travel pass. But again, this confirms...
What do you mean by a travel pass?
Well, it was a card or a pass to enable him to get discounted travel.
Oh, I see.
And the second paragraph refers to him being contracted to Ryanair as flight crew on a 5-year contract, mentioning his base. Page 66 is subsequent correspondence, 29th of November 2018, and by way of context, this was produced for the purposes of securing rental accommodation. Again, clear reference to 5-year contract. And
so these are letters which are then given to Mr Lutz to show people he's applying to things.
Exactly, my lord, yes. And materially they're produced by MCG, and the reference is there to the 5-year fixed term. But the key point, just to emphasise for the avoidance of doubt, there's absolutely no evidence that either Ryanair or MCG told Mr Lutz that he would be engaged for anything other than 5 years, or that his contract would be renewed. There's no evidence.
Or that what, sorry?
Or that his 5-year contract would be renewed. There was no evidence before that, and certainly no submissions below that the express 5-year term was a sham or should be disregarded. In fact, just to finalise this point, before the Employment Appeals Tribunal, it was accepted by Mr Bowers that Mr Lutz could not insist on an extension at the end of the 5-year period. The reference for that is EAT paragraph 204, page 238. Addressing the court now on ground 1 and the point of statutory construction advanced, it is said that temporarily means short term, and the trilogy of EAT judgments starting with Moran were all wrongly decided on this. And this is captured in Ryanair's ground 1 and MCG's ground 5. Before I turn to the directive, it might assist the court if I briefly chart the background as to what led to the directive on temporary agency work. And the reason for this, just to signpost why this is important, it's necessary to place the language used in the directive and in the cases in their particular context. And if I can invite the court to turn first of all to the framework directive on fixed term work, that's divider 12. I don't think the court's been taken to that yet. And of course, this is the framework directive on fixed term work, and it was concluded by the social partners, European TUC, UNICE and CEEP. We can see at the top of 106. And very briefly, looking at the recitals, recital 6 at the bottom of the page makes reference to council resolution inviting the social partners to negotiate agreements to modernise the organisation of work, including flexible working arrangements, with the aim of making undertakings productive and competitive and achieving the required balance between flexibility and security. Point to emphasise there, the aims of achieving flexibility and security are replicated when it comes to the temporary work directive. Later, we'll come to in a moment. And recital 13, bottom right-hand corner, this deals with agency work. Management and labour wish to give particular attention to fixed-term work, while at the same time indicating it's their intention to consider the need for a similar agreement relating to temporary agency work. So just translating that, what that means agency workers were excluded from scope. And if we go to the annex, that's at page 108, again, what we can see in the first paragraph and the last line, there's a reference to better balance between flexibility in working time and security for workers. And the language that we see, or the phraseology we see repeated elsewhere, is in the second paragraph. The parties to this agreement recognise that contracts of an indefinite duration are and will continue to be the general form of employment relationship between employers and workers. Pausing there, we say reference to indefinite, insert permanent and or permanent. And then the fourth paragraph refers to the exception of those placed by a temporary work agency at the disposition of a user enterprise. It's the intention of the parties to consider the need for a similar agreement relating to temporary agency work. And then over the page, paragraph 6, under the heading General Considerations, again you've got the same reference to employment contracts of an indefinite duration, the general form of employment relationships, and contribute to the quality of life of the workers concerned and improve performance. But again, just to pause there, in this particular context, in the context of fixed-term work, there's a different binary distinction: contracts which are indefinite and those which are fixed-term in nature, limited in time. And then, just moving on to the framework agreement, page 110. Clause 4 at the top of the page, that's the principle of non-discrimination. Discrimination, we see something similar in the directive on temporary agency work. But pause there. What the framework agreement is significant for is really two things. One, that the principle of non-discrimination in relation to fixed-term work, it was intended to exclude agency workers, but address that subsequently in the future. And secondly, the recital that contracts of an indefinite duration are a general form of employment relationships, and the binary distinction between permanent and fixed term. Might assist if I invite the court to consider.
Sorry, just give me your 2 points again. 2 headline points on that.
So 2 headline points are perhaps I may reverse the order. First is the concept of indefinite employment being the general form of employment relationship.
Yep.
And the court drawing the binary distinction between permanent, indefinite, and something falling short of that, in that case fixed term. And secondly, that it was intended that to take agency workers outside of the scope of the framework agreement, but to specifically legislate them in relation to the non-discrimination principle. The directive on temporary agency work, and the key point is, my lord, the framework agreement informs the subsequent directive on temporary agency work, and also the phraseology we see in each of the cases we'll come to. The directive on temporary agency work, again, the court's only been taken to certain parts of it, but it's found at divider 15. And recitals 1 and 2 concern Article 31 of the Charter, and just halfway down recital 1, it's designed to ensure full compliance with Article 31 of the Charter, which provides that every worker has the right to work in conditions which respect his or her health, safety, dignity, maximum working hours, daily and weekly rest, and to an annual period of paid leave. And then recital 2, at 4 lines down, again referring to the Charter, will lead to an improvement, a different Charter, improvement in the living and working conditions of workers. But the key points are, the references there are intended to be broad and inclusive rather than limiting in nature. Recital 3 covers what we've just looked at. That's the exclusion from the framework agreement on temporary agency, on fixed term work. Apologies, 5.
Yes, that's correct.
Yes, sorry, I misread the number. Apologies. And then in terms of the recitals, I think page 153, Mr Bowers took you to recital 9 and 11. That's the undertaking's needs for flexibility, but recital 12, directive establishes a protective framework for temporary agency workers, which is non-discriminatory, transparent and proportionate. And in relation to how is that to be achieved, well, we can address that in a moment. That's at recital 14. So the principle of non-discrimination is implemented by ensuring that the same basic working and employment conditions applicable to temporary agency workers should be at least those which would apply to such workers if they're recruited by the user undertaking to occupy the same job. But recital 15 is again of central importance. Again, you see reference to employment contracts of an indefinite duration, being the general form of employment relationship, and recognition that those who have a permanent contract with the temporary work agency have some kind of special protection. So there's a linkage between permanent contract or indefinite duration, employed on an indefinite duration, giving rise to special protection, such as to permit a limited derogation. And we can see that from recital 15. But my Lord Justice Underhill yesterday observed that if, by reference to recital 15, if someone was engaged on a permanent contract, they wouldn't have the same need for the same degree of protection. And it's really, recital 15 is a guideline or guiding line. People who, according to the European legislature, who are in need of protection are those who do not have an employment relationship of a permanent or an indefinite duration. We say that features throughout the framework agreement on fixed term work, directive on temporary agency work, and in the 3 cases that we will come to in a moment. In terms of the provisions of the directive itself, page 154, you've been referred by Mr Ford to the scope in Article 1. Article 2 sets out the aim, and again, it's to ensure the protection of temporary agency workers, improve the quality of temporary agency work by ensuring that the principle of equal treatment set out in Article 5 is applied to temporary agency workers by recognising temporary work agencies as employers, and it refers to setting up a suitable framework. But the key, or the first aim, is to ensure the protection of temporary agency workers who fall within scope. In terms of the definitions, we've got Article 3, and Article 3.1c defines temporary agency worker, worker with a contract of employment or employment relationship with a temporary work agency, with a view to being assigned to a user undertaking to work temporarily under its supervision and direction. We say that Regulation 3.1a largely tracks that. There's no material difference. And the where the centrepiece of the directive is the principle of equal treatment. We can see that set out at Article 5. And Article 5, little 1, principle of equal treatment is the right to the same basic working and employment conditions of temporary agency workers shall be for the duration of their assignment at a user undertaking, at least those that would apply if they'd been recruited directly by that undertaking to occupy the same job. So that is the general principle of equal treatment, which applies to all agency workers falling within scope. Just so that we can just to flag up Article 5.5, because this is addressed in some of the cases which we'll come to. Article 5.5 places an obligation on states to take appropriate measures in accordance with national law and practice, with a view to preventing the misuse in the application of Article 5, and in particular to preventing successive assignments designed to circumvent the provisions of the directive. And there's a reference there to informing the Commission about such measures. But the key point of Article 5.1 and also Article 5.5 is to protect the worker. The obvious point, but it's worth stating. It is not to protect the end user, not to protect the temporary work agency. I'll develop the submission later on, but Ryanair cannot rely upon its abuse in order to deny Mr Lutz the rights that he would otherwise enjoy. And then that's the principle of equal treatment. Just for completeness, at the end of Article 5.4, last two lines, there's reference to such arrangements, that is, in relation to the principle of equal treatment, may include a qualifying period for equal treatment.
Oh, sorry. Oh, I see. Sorry, you mean the end of the first chunk of...
Sorry, of course, I didn't realise that. Yes, the first paragraph of 4. The last two lines of that first paragraph make reference to a qualifying period for equal treatment. Just for noting, Regulation 7 sets down a qualifying period of 12 weeks continuous service.
Yeah.
That's where that comes from. And then finally, just before we break, Article 6 sets out what are regarded as day one rights, and Article 6.1 provides that temporary agency workers shall be informed of any vacant posts in the user undertaking to give them the same opportunity as other workers in that undertaking to find permanent employment. Again,
why is that a day one right? Why are you saying these are day one rights?
Has it? Well,
sorry?
It applies. It's because it's not subject to any qualifying period.
Oh, I see. But it's not important that they're day one rights, is it, for the purpose of the analysis?
No,
I see.
Not from this analysis. It's great.
Yeah, okay, no, that's fine. I just was missing. Okay, yep.
But the key point is the reference to be informed of permanent employment. It's
yes, quite. No, I've got that.
And then Article 6.4 confers the right to be given access to amenities or collective facilities in the user undertaking, in particular canteen, childcare, transport, under the same conditions. Again, so that's another manifestation of it. And finally, just for noting, Article 9, minimum requirements, it permits member states to afford greater protections.
Yep.
My Lord, that might be a convenient moment.
That's all on the article, is it?
On the directive.
On the directive, so sorry, yes. Yes, very well. 2 o'clock.